can we explain to people what is at stake here with this Supreme Court ruling? Because I don't remember many times when you have so many ex-senior justices, associate justices, multiple ex-chief justices, not to mention leading law schools, experts. You also have the Solicitor General, the former Dean of UP Law. So many luminaries in the clearest sense of the word coming out and expressing disagreement. And at the same time, we're talking about an en banc decision. But we know that historically there have been cases like the ISAA versus Greenpeace, right, in 2015, whereby there was a unanimous reversal of a unanimous decision, right, when facts were presented. But Justice, can you explain to our audience what you found, let's just say it, defective, or what are the demerits that you found in the Supreme Court ruling, and what are the remedies that you have thought about? And how do you read the multiple motion for reconsiderations that have been filed so far?
Okay, essentially the way I look at it, the decision of the Supreme Court is concerns the accountability principle in the Constitution, where public officials are held accountable to the people at all times. And the mechanism provided in the Constitution to enforce that accountability is principally the impeachment procedure. And the decision in question touches on the effectiveness of that impeachment procedure as an accountability mechanism. To my mind, it threatens to destroy the effectiveness of that mechanism by imposing too many requirements in its initiation. And therefore, it should be revisited, because to me it's not necessary to impose those additional requirements in order to decide the case. We should practice what Justice Holmes calls economy of jurisprudence. Decide only what must be decided, and decide every case on the narrowest ground possible. The purpose in that approach is to reserve for the future the issues that need not be resolved in the present case. So I think in this case, they should only resolve whether or not the once a year bar applies. Now, as to the need for due process, in the case of the second mode, where Congress itself is the one that files and signs the articles, there's no need to add additional set of requirements for that, because you already said that the article is non-existent anyway, because it was not approved in plenary and because it ran counter to the one-year ban. So it is unnecessary to pronounce those things. That will only, if adopted, unduly hamper the effectiveness of the mechanism, which is accountability.